Hello, everyone. Welcome to MTGB Crime Podcast. You are here at our first episode of Whatever Happened With. And here I will be covering updates on cases that I've already covered. And we just want to see what's going on with the case now, what are the newest updates, and what's been going on. So thank you. Please have a seat. Enjoy this show. If you are not subscribed to the channel, please make sure you do. Smash that thumbs up. And please share out the podcast. Today, I am going to be going over the case of Lasondra Johnson. This case happened in November of 2021. Jada Mills is the sister of Beloveslife, who's best known for mukbang videos on YouTube. I was able to run across a document, and in this document is the Court of Appeals. And so I'm going to go over this document. It says State of Iowa versus Lasondra Johnson. And I just want to see what's going on, because when I did my first video, November 15th of 2021, there was a lot of details that I did not know. And a lot of information is limited coming from the news. And I didn't even have an affidavit or anything at that time. But what I've been noticing is a lot of people are watching that video. So I wanted to do an update because of that. And thank you guys so much for tuning in and watching that video, which prompted me, to find out, hey, what's going on? Is there some new information out? And so this document is coming out of Fine Law. So I am looking at the State of Iowa versus Lasondra Johnson 2023. Decided October 25th, 2023. Lasondra Johnson appeals her conviction and sentence on one count of assault causing injury. Her conviction stemmed from events that occurred one night in November 2020 when Johnson unalived Jada Young Mills. On the night, Johnson accompanied her boyfriend to his mother's house and waited in the parked vehicle in front of the house while her boyfriend went inside. While she waited, 3 women Johnson knew came by and got into her vehicle to talk with her. Although their conversation was friendly at first, Mills and Johnson started to argue and yell. Johnson ordered Mills out of the vehicle before pushing her out. Johnson exited the vehicle and the two began punching and wrestling each other. Others intervened and separated the women, with Johnson returning to the passenger seat of the vehicle. But while her boyfriend stood by the passenger door between her and Mills, Johnson opened the door and fired her 9mm handgun. The bullet struck Mills in the back, and Mills later died. The state charged Johnson with first-degree murder. Eyewitnesses to the shooting and the events just before it testified at the trial. The state claimed that the fight between Johnson and Mills was over when Johnson fired the gun, while Johnson claimed she fired in self-defense. Ultimately, the jury acquitted Johnson of first-degree murder, but found her guilty of a lesser included offense of assault causing a serious injury. The district court sentenced Johnson to 5 years in prison and ordered her to pay $150,000 in restitution to Mills' heirs or her estate. So the jury's instructions on appeal, Johnson first challenges the jury's instructions. They review the jury instructions for correction of legal error. In doing so, we view the jury instructions as a whole and determine whether they correctly state the law and are supported by substantial evidence. A jury instruction is improper if it is unrelated to the factual issues to be decided by the jury. Evidence is substantial enough to support the requested instructions when a reasonable mind would accept it as adequate to reach a conclusion. So Johnson contends that insufficient evidence supports two of the instructions addressing her justification defense. She challenges instruction number 55, which informed the juror of three situations in which the defendant's use of force would not be justified. Johnson objects to the portion of the instruction number 55 that states her use of force was not justified if she was engaged in the illegal activity of assault. In the place where she used force, she made no effort to retreat, and retreat was a reasonable alternative to using force. Johnson also challenges instruction number 58, which requires the jury to presume Johnson's reasonably believe the use of deadly force was necessary if the evidence showed Johnson knew or believed Mills was unlawfully entering Johnson's vehicle by force. Johnson complains about the section's half of that instruction, which states that the jury need not give the presumption if Johnson was engaged in the crime of assault when she used the deadly force. She argued that the facts do not support giving either instruction because the evidence did not show she was engaged in an assault when she shot Mills. So there is conflicting evidence about what occurred before Johnson was hit with this weapon. Although there's evidence supporting Johnson's claims that Mills was still coming after her when she fired, there's also evidence contradicting that. Eyewitnesses testified that the fight was over once Johnson was back inside of the vehicle. One of those witnesses testified that while Johnson's boyfriend tried to hold the vehicle's door shut, Johnson pushed the door open and pointed the weapon at Mills and asked, "Where is your gun at now, B?" before firing. From this evidence, one could find that Johnson's acts of pushing Mills out of the vehicle, fighting her outside of it, and displaying the gun while taunting Mills constituted either one continual assault or a series of assaults. What occurred was a question for the jury to resolve. Noting the jury in function is deciding disputed factors, questions in a criminal case. So before a reasonable mind could conclude Johnson was engaged in an assault when she fired her gun, the court did not err in finding instruction number 55 and 58. We affirm Johnson's conviction. Restitution. Johnson next challenges the order requiring her to pay $150,000 in victim's restitution under Iowa Code Section 910 19.3b1 2020. That revision requires the court to order a defendant to pay at least $150 in victim's restitution if convicted of a felony in which the act or acts committed by the offender caused the death of another. On the appeal, Johnson contends the provision violates her due process rights by allowing the court to award restitution without a jury finding she caused Mills' death. The state contends that Johnson failed to preserve error for our review. At sentencing, Johnson argued that awarding victims restitution would violate the excessive fines clause of the United States Constitution and the Iowa Constitution under the 8th Amendment to the United States Constitution and the 8th Amendment, Article 1, Section 17 of Iowa Constitution. The state contends that Johnson failed to reserve error for a review. At sentencing, Johnson argued that awarding victim restitution would violate the excessive fine clause of the United States Constitution and the Iowa Constitution under the 8th Amendment to the United States Constitution and the 8th Amendment of Article 1, Section 17 of the Iowa Constitution. In a case involving an unintentional or negligent offense, instead, Section 910.3b is limited. In a case involving an unintentional or negligent offender, instead is limited to an offender who was demonstrated a willful and wanton disregard for the rights of others in the commission of a crime. The jury did not find anything that showed that shooting Mills was an intentional act or a reckless act. The jury found that Lasondra Johnson did an act which could have been an act merely to place others in fear of immediate physical contact, which would be injurious or offensive. They didn't find necessarily that she shot on purpose. Johnson makes essentially the same argument on appeals. Even so, Johnson alleges that restitution awards under Section 910.3b is an illegal sentence. Restitution is a form of punishment, and thus the rules of error preservation do not apply. After Johnson was sentenced, the Supreme Court held that jury must find the defendant caused the death of another before the court can impose restitution under Section 910.3b. Holding that imposing restitution under Section 910.3b without a jury finding that the defendant's act caused the death of another violates the 6th Amendment to the United States Constitution. The court says that the effect of its decision should be relatively narrow because cases where the $150,000 in restitution would be assessed on a defendant who was not convicted of a homicide felony are and likely will remain relatively rare. Although the district courts and parties did not have the benefit of Davison when Johnson was tried and convicted, its holding still applies. Thus, we reverse and vacate the award of the $150,000 in victims' restitution under Section 910.3b. Finally, Johnson contends the district court abused its discretion in sentencing her to 5 years in prison. We reviewed sentencing decisions for corrections of error at law. Because the sentence is within the statutory limits, we will not reserve it without a showing that the court abused its discretion. The sentencing court abuses its discretion by exercising its discretion on, on grounds or for reasons clearly untenable and extent clearly unreasonable. Johnson argues the court failed to exercise its discretion by sentencing her in accordance with a personal fixed sentencing policy. She claims the court statements show it adhered to a policy of incarcerating defendants who use a gun to commit an offense that results in the death of another. She also argues the court focused on improper sentencing considerations in imposing her sentence by focusing on an unproven offense because the court stated she was convicted of killing another human being without any such finding by the jury, noting that if the court improperly considered unproven or unprosecuted conduct, remand for resentencing is required. At the sentencing hearing, the court stated, "I have considered the arguments of the defense, a request for a deferred judgment. I do not believe, given the facts and circumstances of this case, history of this case, that a deferred jury is warranted. I have considered all other options, including probation. I do not believe probation is appropriate at this time either." The jury reviewed the case. The jury did not find that Ms. Johnson was justified in her behavior, and the jury returned a verdict in the felony offense resulting in the death of another individual. In some, a gun was used, in some, a gun was discharged, and in some, Ms. Johnson killed another human with the use of that gun. And it's the court's opinion, given those short, simple facts, that a prison sentence is appropriate. In pronouncing judgment and sentence, and the court was considered the factors set out in Iowa Code Section 9015, including the nature of the offense, the attending circumstances, your age, your character, and or chances for reform. Again, for the reasons already stated upon record, but in addition, the court does find the sentence to be appropriate, considered the recommendation of counsel, the nature of this offense, your age, your limited prior record, but nonetheless a record, and the sentencing goals and objective to the court. In support of her claims, Johnson also points to following statements the court made after her attorney objected to the amount of the appeal bond. As far as the appeal bond, the court has already articulated the reasons for it. With all due respect to the defense, the fact that the assertion is that the defendant's not a danger to the community in light of the fact that we are here for the very reason she killed another human being, frankly, doesn't hold water. By conviction, as we sit here now, not by allegation, but by conviction, she stands before the court convicted of killing another human being. She absolutely is a danger to the community in the court's eyes at this point. She took a firearm under whatever circumstances either the defense of the prosecution wishes to present it. The court sat through the testimony, and the jury ultimately rendered a verdict finding that she took it, she fired it, and she killed another human being. So, consequently, this is the court's appropriate finding regarding the appeal bond, and with all due respect to the defense, any objection to that is overruled. The record does not support Johnson's claim that the court acted in accordance with a fixed policy in sentencing Johnson to a 5-year prison sentence. In denying Johnson's request for a referred sentence and deciding against probation, the court focused on the nature and circumstances of her offense. In particular, the court focus on Johnson's use of a firearm, a deadly weapon, and emphasize that Johnson's act resulted in Mills' death. But there is no showing that the court focused on those facts because it was adhering to a fixed sentencing policy. Rather, the inherent danger of wielding a firearm near a group of people and the deadly result bear on the question of which sentence best protects the community. Nor does the record show the court relied on an unproven offense when sentencing Johnson. Johnson's focus on the court's statement that she stood before it convicted of killing another human being. She argues the statement is incorrect because the jury acquitted her on charges of murder, manslaughter, and attempt to commit murder. She also claims that the jury could have convicted her of assault causing injury solely based on injuries to Mills' face that she incurred during the fight. But the evidence at trial shows that Johnson was the only person who fired a gun that night, and Mills died as a result. When a challenge is made in a criminal sentence on the basis that the court improperly considered unproven criminal activity, the issue presented is simply one of the sufficiencies of the records to establish the matter relied on. There is no general prohibition against considering other criminal activities by a defendant as factors that bear on the sentence to be imposed. The sentencing court may rely on sworn testimony presented during the trial to conclude that a defendant committed other crimes, even if the jury acquitted the defendant of those charges. Sentencing judge is not required to deviate from the judge's own characterization of the nature of a crime committed based on sworn testimony, simply because the jury has characterized the offense differently. Judge and jury have separate and distinct roles in the criminal justice system, and sentencing is the sole prerogative of the judge. There is sufficient evidence showing that regardless of her intent, Johnson's actions still caused her death. Because the sentencing court properly exercised its sentencing discretion and did not rely on an improper factor in imposing sentence, we affirm Johnson's prison sentence. We affirm Johnson's conviction on the charge of assault causing injury, affirm her prison sentence, but reverse and vacate the $150,000 in victims' restitution awarded under Iowa Code Section 910.3b. We remand for a new sentencing order consistent with this opinion. Among the evidence admitted at trial was a surveillance video taken from a house down the street. The video does not include audio because it was dark, and the video was shot from a distance. It is hard to see more than general movement by Johnson, Mills, and witnesses.